Hey everyone, Harry here to talk about Judge Cannon's rejection of three motions, two motions to dismiss and one for a so-called bill of particulars by Trump's co-defendants in the Mar-a-Lago case, Walt Nauta and Carlos de Oliveira. The headline here, I think, has to be that Cannon made pretty quick work of this motion. I think she's gotten it maybe within the last week, but certainly within the last two. That's point one. And point two is with a little bit of an asterisk that I'll get to. It's just sort of work a day, one foot in front of the other, solid, and in particular, no snipes or low blows at the government, which has been her MO even for orders she has issued that rule for the government. All right, everyone remembers, I think, Nauta and de Oliveira, they're the people who work at Mar-a-Lago who are dragged in by Trump and wind up helping to obstruct, moving boxes around, knowing what's going on, lying. Does Nauta when they first go to to Washington and talk to agents. They now say, oh, there's not enough in the indictment, and we also would like a bill of particular, or Nauta asked that. I'll get to that in a moment. So on the indictment, she basically says, look, there is enough here. It tacks to existing law. There's a little bit of discussion about the word corruptly and whether it's vague and might in fact be affected or narrowed or changed by a case up at the Supreme Court. But she notes properly, the 11th Circuit has rejected already, that's the court above her, a vagueness challenge, which is a challenge that says it's so kind of amorphous, don't even know what we're defending against. On corruptly. And so that's out the window. And otherwise, you can just see what they've said, very much tacks to the law. So there's nothing they need. Similarly, on a bill of particulars, the indictment is specific enough to tell Nauta what he needs to defend against. That's what a bill of particulars is for. They say, I just can't figure out what I'm trying to defend against. That happened in the Fulton County case, you may remember, when McAfee said one charge of violating one's oath was really just too puzzling because there's so many aspects to an oath to uphold the Constitution. That was a big problem in Fulton County, continuing this aside because they didn't have a way to quickly remedy it. In the federal system, even had she found for Nauta here, it's something that a prosecution can stitch up with just adding some language to the indictment. But she says it's not necessary and so goes through. Now, the only thing is she puts her ruling very much in terms of the language of the indictment rather than some broader legal conclusion of sufficiency. And the reason that catches everyone's attention at this point is she has made certain rulings that she's indicated in a way that really gives alarm to the prosecution and people who are following this around the country, that she could revisit it at trial and make a legal ruling or pretty much force the jury to make a conclusion, at which point it could not be revisited because the principle of double jeopardy in the Constitution says once a jury is sworn in and Trump is, there facing that judgment, if the case is dismissed on those grounds or a jury holds against it, he cannot be retried. In a similar way, she's saying, if you look at it carefully, little more than the indictment is accurate and solid as to form. It would be, one way to put this. It tacks what the law says, etc. But so she does leave the door open, and by now they don't need a big hint to try to push on that open door come trial. where they can make a follow-up claim saying, all right, we couldn't dismiss it, but now under the evidence, it can't be proven, or revisit this question, but really in terms of the legal sufficiency. And then she would be doing it in a way that would make it irremediable up top. But I don't think our antenna would be buzzing about that prospect if it weren't for what's come already from her. And basically, if you look at this opinion, just on its four corners, it's remarkably enough, just solid, 1 foot in front of the other, a rejection of claims that should be rejected with no asides or snipes at the government. Maybe that shows that she plays by a different rule book for her patron, Donald Trump, or the person who put her there, and that she might hope in some world would elevate her again. Or maybe it shows she's kind of learning her lesson, or at a minimum picking her spots, and not taking every occasion to slap the government around or to really telegraph in neon, hey, I might revisit this going forward. But there's really nothing for the prosecution to challenge here or bring up to the 11th Circuit. It's basically a workaday opinion of a workaday issue, and it tells Nauta and de Oliveira they've got to go forward. And that's significant in and of itself, because the evidence against them is very strong, and if their interests, if lawyers soberly assess their interests, it really makes sense for them to be pleading and cooperating against Trump. To the extent they haven't done it so far, one sort of surmises, the hope that no matter what happens, both of them would hope and think that they'll be, protected in some sense and given employment and the like by Trump for the rest of their days. They may not be have good employment prospects in the government otherwise, but if you just assess the legal prospects, the cost of that kind of patronage going forward looks like a few years in jail, and whether they'll revisit that calculation as it comes closer to trial, and they really do have to face the music, remains to be seen. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.